Goatsi, Kaitawa Hopa, Waikaiute, Dushinamenti Maitza Eshe, Ushatanushta, Kohayawashita. It's really hard to follow Veronica. I'm so proud of her. My name is Donalyn Saracino, and I am from the Pueblo of Acoma. I am a mother, a daughter, a granddaughter, a niece, an auntie, and much of what Veronica has said, I've heard her story many times, and it always hits my heart because this is why we do what we do. And this work is so, so important to all of us. I'm a licensed social worker and started in clinical social work. Addictions counseling. I used to run a compulsive gambling treatment clinic here in Albuquerque, worked in the prison. And then I found my way, after the birth of my second child, a stay-at-home mom, which I was thoroughly enjoying. Tribal leadership found out I was home and quickly approached me and asked if I would be willing to help build our tribe social services program, which at that time was being run by the Bureau of Indian Affairs. And the Pueblo of Acoma had recently contracted to be able to provide those services. And not knowing anything about child welfare, I kindly declined. And then I was reminded by my uncles that when our tribe asks us to do something, we don't decline because we are born for our people. And before I move further, I actually have one of my uncles here today, Dennis Lorenzo. I was raised by my grandparents. And raised in a really loving environment. My home, my grandma, my grandpa, my aunts, my uncles, my mom. And that's the way we are raised in tribal communities. I always knew who my parents were. I had interaction all the time with my mom, but I was raised by my grandparents, like many of my cousins who are not cousins, they're my brothers and sisters. And so I really, family connectedness, cultural connectedness is really important for all of us, for our children. And so I decided I would accept the position as director for social services, even though I knew nothing about child welfare, and really quickly learned ICWA and had a really positive interaction with our tribal leadership, who were very supportive of bringing our children home and having the homecomings that Veronica had shared about earlier. So currently, I am the director for the Office of Tribal Affairs with CYFD's Office of the Secretary, and I started in that position in October of 2019 as the tribal liaison, and really quickly realized this is more than a one-person job. And so slowly have been building the Office of Tribal Affairs within CYFD, and thanks to legislative statute of the Indian Family Protection Act, we are now codified within the department. And so I do have some staff here. Grace Naylor is our administrative consultant. Grace. Many of you have had much interaction with her, I'm sure. We have Dr. Cristiana Cisneros, who is our Indian Child Welfare Training Coordinator, also recently hired a Behavioral Health Training Coordinator, Juvenile Justice Services Training Coordinator, QA Manager, or Quality Assurance Manager, and a Protective Services Training Tribal Coordinator as well. And so it's a pleasure to be here with you today. Thank you so much. And I am excited and honored to always share space and share this platform with somebody who I have admired and looked up to and felt so much support and encouragement from since I entered into the field. So Judge Romero.
Thank you, Donalyn. And again, a round of applause for Veronica. She is amazing and really tells a heart-wrenching account of what it means to be an Indian child caught up in the child welfare system. Thank you. and I'm sure we'll hear much more about you as you continue your education and be in the fight for the good of all people. Thank you so much. I'm going to be very brief with my introduction. I'm John Romero, born in New Mexico, norteño proudly, and a former judge in the Second Judicial District Court here in Albuquerque, New Mexico. And I see many of my still colleagues and friends present today, naturally, and I admire the work that they do and am very supportive of all the new innovations they're creating, not the least of which is the ICWA Court and the results that are coming from a meaningful relationship with those parents and children that come into our system, not voluntarily, but because they're brought into it, and the great results that are being realized through this ICWA Court and other ICWA courts throughout the country. My wife of 52 years made sure that I called her this morning when I got here. That's the way she's always been, looking out for me. And we have 2 children. They're not children, they're in their 40s. They have children of their own. And, you know, I'm proud to say, as the governor suggested, we also have great-grandchildren, which remind me that life goes on and that we have a duty to those that come after us to be models, to be encouraging spiritually and otherwise. And it's particularly important when we do the work that we do in the child welfare system. I do want to say that there's a mistaken impression about the child welfare system. Particularly in the media lately, CYFD is bearing the brunt of the child welfare system. But each and every one of us in this room today are part of that system. We need to work together to make things better for the families and children who come into our system that are there against their will, and yet we have a duty to do the best for them together. Not CYFD by themselves, not courts by themselves, not attorneys by themselves, but all of us together as a system that will improve and make things better. I'm going to talk today about probably something we don't want to hear, the history of how we've treated Indian people in this country from 1492 and on. And it's not unlike what you have to do before you go to the doctor. But before I talk about that, I want to give you a quick overview of what I will leave you with today. As a result of what I present and what Donna Lynn will present later, we're going to have an opportunity to consider the history of Indian people in the United States. We're going to be able to appreciate the negative impact of federal Indian law and policies on Indian people back before I was born, certainly, and still continuing today. As Veronica alluded to, the issue of ICWA being challenged, its constitutionality, and whether it will continue to exist as we have known it since 1978. I'm going to very briefly talk about the purposes of the Indian Child Welfare Act, but you all can read the statute yourself, the code yourself, and see what it says in there. But I'm just going to do a brief introduction to the Indian Child Welfare Act. And finally, the best part of all of this will be understanding IFPA, the Indian Family Protection Act, the creation story. So all of us have had an opportunity, I call it an opportunity, to go see our doctor. And if you all have had a similar experience to mine, you have to fill out a form that talks about not only your history, but your mom and dad's history, and even your grandparents' history. A doctor who's going to treat us is not going to hazard a guess as to what they are going to do with us until they know our history, our medical history, for not just, as I've indicated today, but generations past. And kind of like talking to the doctor, we know as attorneys, as legal professionals, that our clients have to be honest with us. They can't keep anything back if we're going to accurately represent them. So too it is when you go to the doctor. If you hide stuff, few problems have ever been resolved by ignoring them. So the history of Indian people in the United States is very much like that. a very brief and thumbnail history starts with colonialism. The doctrine of discovery, I will talk a little bit about that. Peace treaties, of course, were part of the history of Indian people in our country. Peace treaties that were ignored by the dominant society. Broken promises, quite frankly. And then a very dark part of our country's history and Indian history in this country was the whole notion of assimilating Indians into the mainstream. Part of that was manifested in boarding schools and many other things as well. The Allotment Act, I'm not going to talk about that. That's for a future discussion. But finally, the era of termination in our country's governmental policies. And while one might say, well, we weren't going to terminate, Indian tribes, we were going to terminate the government's relationship to them. But in doing so, leading up to that era in our country's history, we were terminating Indians, or we were trying to. But as Veronica so eloquently said, we're still here. We're not going anywhere, and we're going to be here. Not an exact quote, but that's the message I got from her. So colonization, what is that about? We've, in our modern history, have not experienced being subservient to an outside force. It's external control that's imposed upon those who are being subordinated by the dominant society. Colonization in our country began with the arrival of the Europeans. And what did colonialism do? Well, it damaged those who were the subservient ones, those who were dominated by the dominant culture. And some history talks about what it felt like to be colonized. Dispirited, devalued, you're lesser than. In fact, you're not even a human being, is how some folks who were subjected to this colonialism talk about. Not just in our country, but in other places where people have invaded other countries, have taken over the religion and the culture and the government of a country that already existed. So one of the gross examples of the impact of colonialism goes back to 1599, when the Spanish were here in New Mexico. And it's referred to in the history books as the Acoma Massacre. Without going into a whole lot of detail about what led to what is known as the Acoma Massacre in 1599, in fact, January of that year, Don Juan de Oñate, someone who was revered in the history of New Mexico, basically to pay back for what had happened to some of his soldiers by Acoma people, basically launched a punitive expedition into the Pueblo of Acoma. And it led to the deaths of about 800 Acoma men, women, and children over a period of 3 days. Several hundred survivors from that massacre met with perhaps even a more drastic fate. They were enslaved or otherwise severely punished. What was Don Juan de Oñate's punishment for these people? Well, every male above the age of 25 had his right foot cut off, and they were enslaved for not less than a period of 20 years. Younger males, 12 to 24, their right foot was spared, but they were also enslaved. What are you talking about? Slavery in New Mexico? Yes, it did exist here to some measure, at least spiritually, psychologically, slavery still exists. All females above the age of 12, think about that, a 12-year-old kiddo also having to be enslaved for a period of 20 years. If you read the further history of the Acoma Massacre, the King of Spain didn't take too lightly to that. Even he recognized that that was outrageous. Don Juan de Oñate was reassigned and perhaps stripped of his authority. One of the other interesting things about the history of Indians in New Mexico is this whole notion of being discovered. I don't know if any of you are old enough to remember a black comedian, I can't remember his name now, but he was talking about discovery. And he said, that's like me and my girlfriend sitting in the back of my Cadillac in New York City and somebody comes around the corner and says, "Get out of your Cadillac, I just discovered it. You don't own it anymore." Well, the doctrine of discovery, what was that? It was the notion that lands in this country were discovered by those who arrived here, and those who already occupied it and used it from, as Professor M. Hall used to say, time out of mind. Veronica used the more appropriate term, time immemorial. But they were already here. How do you discover and take over something that's already being utilized and occupied in a way different than being the owner of that? The relationship between Indian people and the land is different from, I own 4 acres and it's mine, you can't be on it. Rather, it's something that benefits everyone and is not to be owned, but rather to be valued and considered as vital to the survival of all people, not just those who own it. Along with the theory of discovery came the notion of conquest. And no less than our United States Supreme Court back in 1883, in one of the first cases that dealt with, in a relevant way, with Indian issues, Johnson versus McIntosh. In that decision, Chief Justice John Marshall at the time described the American judicial system as the courts of the conqueror. How many of you would feel comfortable going into a courtroom when you're the one who allegedly has been conquered and this is the court of the conquerors? Do you think that's a fair and balanced way of approaching litigants in your courtroom? Even today, is there some feeling among all litigants, but particularly Indian litigants, that we're still in the courts of the conqueror, that their voice, their opinion will never be heard or considered as a final outcome? Well, the consequence of Johnson versus McIntosh is basically Chief Justice John Marshall, who apparently benefited from this decision in that he acquired land as well, but land that was formerly occupied and utilized by Indian people was now land of the government, which they sold and made money off of, including, according to history, Chief Justice John Marshall. Well, in order to view people as lesser than, there's a concept of what does it mean to dehumanize someone? The court, in many of its decisions, came to be known as the dehumanizing court. By that I mean the U.S. Supreme Court. So in Montoya versus the United States, basically there was a lot of derogatory terms labeling Indian people. Things like, they lack mental training, they're savages, they're uncivilized. I would ask myself, who's uncivilized in the way we're dealing with real live human beings? In another case in 1903, Lone Wolf versus Hitchcock, essentially the Supreme Court unabashedly said, we don't have to own up to the treaties, we don't have to honor them, because after all, Indian people that we've entered into treaties with are ignorant and dependent upon us. They don't know what's going on anyway, so we don't have to honor those treaties. The history of the U.S. Supreme Court in those days was fraught with vestiges of racism, not just in that court, but in federal law and policies that followed. The Supreme Court referred to Indian people as savages, as those who were barbarians. And the courts, including the U.S. Supreme Court, dealt with them accordingly. Now, most of us remember from history the notion of manifest destiny. What a weird notion. And that notion was that in this country, this new country, we were destined, in fact, divinely ordained. We said, God wants us to do this. It's okay with him to conquer and control a part of the North American continent that was already occupied, that it was our destiny, and we were blessed to be able to engage in westward expansion and take over things and over people that were already there. And that whole notion of manifest destiny was basically based in the pervasive belief that American culture was superior to anything else around us. that Indians had long been perceived as inferior and not worthy because they were uncivilized. That's what motivated much of U.S. policy and court opinions and decisions. Much of this amounted to the genocide of Indian people, and people, some folks have said, well, that's kind of harsh to talk about genocide. Well, it was cultural genocide for sure, some people would say, but it was also physical genocide, eliminating a whole group of folks because we felt superior to them, we, the U.S. government. So Indian people suffered through years of war and genocidal acts that, Western colonizers felt empowered to take on because, after all, we were superior, and we were going to claim these lands, and some of which had valuable minerals, including gold. The California 49ers issue, that was one of the things that we learn about the gold rush, but we don't learn about those folks who were already there and who were removed and displaced because they didn't know about gold and they didn't value it, so only the U.S. government did. So the policies of our country at that time, our government, was basically to get rid of Indian people so they wouldn't be in the way and we could take over the land and the minerals and so forth that were there. Well, there are a number of examples of what genocide looked like. Indian scalps, scalping Indians, you could get paid for that. And that, of course, resulted in the death of those who were being scalped. Another way of committing genocide was destroying food sources, the land that they had grown up in, that they were accustomed to, that they knew the patterns and the history of how when crops were to be planted and when harvesting was supposed to take place. And mostly all we hear about is the killing of the buffalo on the Great Plains. Not that that's insignificant, but that was a vital, not just food source, but a source for many other things that Indian people used the entire buffalo for, not just the sport of killing them and leaving them out on the plains to rot. Talk a little bit more about boarding schools in a moment, but ceremonial practices of Native Americans were also outlawed by the government. Christianizing these savages was a goal of many well-intentioned, misdirected church groups. So let's talk a little bit about boarding schools and the notion of assimilation. Suffice it to say that between 1880 and 1902, over 30,000 Indian children were removed from their families and from their tribal communities and placed into boarding schools, not foster homes. And that took a great toll. So boarding schools were one of the genocidal methods used by our government. And the notion was that you could separate Indian children from the homes and their families and their communities, and they would come out better. You would civilize them. Hair was cut off. They were punished if they spoke in their native language. If they even appeared to be practicing some of their cultural religious practices, they were punished for that as well. They lost their identities. They were forbidden to speak their language, so naturally they lost knowledge of their language. Cultural practices that they had been introduced to were eliminated and forbidden. And their spiritual beliefs, that every parent has a right to teach their children, were forbidden in those schools, and they were forced to convert to and accept Christianity and Christian principles. Well, you got a little flavor from listening to Veronica speak about what that does to one internally, to your mindset, to your spirit. So many children died from certainly physical abuse, sexual abuse in these boarding schools, but many of them died from the emotional pain that they suffered from being separated from their families and their communities. Some who were able to return to their communities didn't understand their language, didn't know what cultural practices were in place because those had been stripped from them, and it was hard to assimilate back into your community because you didn't know anything about it. So those cultures and relationships were lost to many of these kids who had been forced into boarding schools. Another method of genocide was removing Indian people from their homeland. The Removal Acts. Indian people were forced to walk large distances away from their homelands into places that were designated as reservations. The traditional food that they had planted, harvested, was not available to them anymore. Moving from the fertile areas of southeastern United States, Georgia, the Carolinas, and so forth, to nothing against Oklahoma, but it's not quite green and lush like Georgia and North Carolina and South Carolina. So one person who's looms large in U.S. history because of his skills at being president and as being a great leader of military, Andrew Jackson signed the Indian Removal Act in 1830. And I already referenced, the removal of Indian people from the southeastern part of the United States, and we commonly, if we heard about it at all, was about the Trail of Tears. Indian people refer to it as the Trail of Tears and Death, because imagine marching from that area of the country to Oklahoma in winter without any provisions, that not everybody survived, especially young children, especially those who were frail in their health already. Thousands of people indeed died along the way from their homeland to the reservations west of the Mississippi in Oklahoma and other places. New Mexico wasn't immune from that. Brigadier General James Carleton had come from California to New Mexico when the Confederate Army invaded New Mexico. In fact, if you read your bar bulletin, there's a trip to Glorieta Pass to examine that site and the victory that took place there to turn the tide of the Confederate invasion of New Mexico and chase them out. James Carleton got here too late. By that time, the Battle of Glorieta Pass was already won, and the Confederates were heading back south to Texas and other places. However, he was one of those who devised this wonderful plan that he had been exposed to while in California, a pilot reservation system. And he had had occasion during his prior trips to New Mexico to be down near the Santa Rosa area where the Pecos River flows, and he had seen this, what he envisioned as a wonderful place, a bosque, a forest along the river. And he thought that would be a great place for a reservation. And he put everything in his power of command over Union forces here in New Mexico, and along with the New Mexico militia, to force the Navajo people and the Mescalero Apache people to this wonderful place called Bosque Redondo, just south of Santa Rosa, where Fort Sumner is located. Never mind that his experts had gone down there and said, there's nothing that we can make of this river down here. By the time it gets down to Bosque Redondo, the water is brackish. You can't even drink it. And the heat and the pests that exist down there, no crops will grow. He disregarded them because this was his plan, and he wanted to force the Navajo and Apache to leave their homelands. And how did he do this? He ravaged them. They raided their farms, their villages, destroyed everything in sight so they had nothing to eat or a place to live. So this was, again, during the Civil War, of course. And he pretty much had free rein because his bosses back east were busy conducting the Civil War. But the plan was to move against their will the Apaches and the Navajos to Bosque Redondo, to civilize them, to teach them to be farmers and to raise animals, something that that they were not, that was not their way of living. And incidentally, one of the things that apparently was never taken into consideration in that in those days, the Apache and the Navajo weren't exactly bosom buddies, but we're going to put them together in this pilot project to civilize them. So the Navajo Long Walk to Bosque Redondo involved about 8,500 men, women, and children who marched from northeastern Arizona, western New Mexico, over 300 miles to this place south of Santa Rosa, to this paradise as envisioned by this general as a wonderful project, a reservation at Bosque Redondo. By the way, there's a museum there, as I understand it. It's one of my intents this summer to go there and visit that museum at Bosque Redondo. Go east on Interstate 40 to Santa Rosa, hang a right, go down about 50 miles on US 84 to Fort Sumner, and that museum is there. I am told by those who have seen it is very emotionally moving and compelling that we as a government imposed this on Indian people for the sake of making them better. One of the little known facts is that this general, because of his exposure to what happened in California, actually believed, he was kind of a junior geologist, that there was gold in them there hills on the Navajo reservation. So his motives for removing them weren't exactly pure. He believed that once the Indians were removed, that they could discover gold in Navajo country. Of course, other kinds of gold was subsequently discovered, coal, oil, gas, other important minerals. But one of the things that I want us to be mindful of is that Indian people today still celebrate some memorable events. And one of them is the Navajo Walk Home. One of the few tribes that actually, because of a peace treaty entered into in 1868, were able to return to their homeland. And the government treated them differently then because they knew that the project had failed at Bosque Redondo, and they because of this legal agreement, this treaty entered into on June 1st, 1868, they actually provided some rations and other minimal assistance to allow the Navajo to walk back to their homeland. I can't begin to imagine what that felt like. Just the news that you could go home, just the news that you could be connected again to your homeland and be back where your people had existed for time out of mind, had lived there and were connected spiritually to the land. So not too many years ago, June 1st, 2018, Navajo celebrated the 150th anniversary of the 1868 treaty. I hope if you remember nothing else about Indian practices and ceremonies, you should never set a hearing on June 1st and expect those folks who belong to Navajo Nation to be there happily. There are so many other customs and ceremonies in our state. I think Judge Begay very generously provided a list a couple of years ago when I was still on the bench of the various holidays and ceremonial times of our pueblos and tribes in New Mexico. Be aware of those. I think they're available online if I'm not mistaken. If they're not, Judge Begay will be happy to provide them to you, I'm sure. I'm speaking for her when I shouldn't, but I know her and I'm sure she'd be happy to provide that to you. Don't be so ignorant about what goes on in our own state so as to ignore what's valuable and important to other folks. We would never dream of setting a hearing on July 4th or on Good Friday, although we still have court on Good Friday in some places, or on Christmas Day, or something as secular as New Year's Day. We observe those and we hold those as important, mainly because we have a day off with pay, to be very honest with you. So let me talk a little bit about some of what Veronica already shared with us, and that's trauma that Indian people endured. And I've heard so many people say, well, why do Indian people today still have trauma when, all of these atrocious things that happened to them were back during the Civil War era? I think Veronica's testimony is that it's happening today. Historical trauma is very real. It's passed on from generation to generation. It's intergenerational. There's even science, not that we need it. We have evidence right before our very eyes in many of our Indian Child Welfare Act cases, IFPA cases, but there's a scientific label for the study of intergenerational trauma, historical trauma, epigenetics. And that science actually says that there are genetic changes for those people who suffered through great trauma, and that it's actually genetically passed on for generations. The director of SAMHSA Center for Mental Health Services is noted in a publication of having made this quote: "An American Indian or Alaskan Native who is over the age of 30 is only one generation removed from the boarding school era." Think about that. Who do you have in your courtroom that fits that definition? Who do you have in your courtroom in these cases who have children that have inherited that intergenerational trauma? Think about that. There's more to it than what meets the eye. One of the trainings that I've attended, the presenter uses an iceberg, and I've used that metaphor of an iceberg as well. We're pretty far south from the ocean, but icebergs used to be here in New Mexico. And the point that he makes is that an iceberg floating in the ocean, you see 20% of it above the surface, but the most dangerous part, evidence the Titanic, is below the surface. We need to be mindful of that metaphor, that the people we see in our courtroom, whether they're Indian or not, there's so much beneath the surface that we're unaware of and that we should be sensitive to and not be judgmental about. I'm looking for Twyla because she's going to wave a pink card at me sometime soon. Okay. Okay, thank you. The federal government, when we're talking about laws, particularly ICWA, has a trust relationship with Indian tribes. And part of that trust relationship is that the federal government is supposed to look out for the welfare of tribal members and their land. There are a number of things that trust relationship relates to and is required under the federal government, but it's significantly protection of tribal sovereignty and their rights of self-governance, including especially making decisions for their families, for their children. So almost 45 years ago this November, Congress passed the Indian Child Welfare Act. And it was an unusual form of federal legislation. It was not, it was not setting standards of how we were supposed to behave necessarily, but it was a remedial piece of legislation to correct wrongs from the past. It was intended as a remedy. As we know, ICWA is now under constitutional attack. Not ironically, maybe cruelly, the U.S. Supreme Court heard arguments on the 44th anniversary of the passing of ICWA. I don't know if that was intentional or coincidental. Certainly insensitive, in my humble opinion. Leading up to the passage of ICWA, Congress held a lot of hearings, and a lot of findings were made by Congress that led to the passage. And of course, we've all heard the data, the statistics on the number of Indian children that were being removed from their homes, from their tribal communities, and placed for adoption with non-Indian families. Among the findings also were that, in child custody proceedings specifically, state agencies and courts, all of us involved in the child welfare system, not just the child welfare agency, we failed to recognize the essential tribal relations of Indian people and also the cultural and social standards that occur among the different pueblos and tribes, but even within the pueblos and tribes themselves. Not everybody in Navajo Nation has the same customs. There are chapters within Navajo Nation, and each chapter is unique and has their own view of how things are done and how things are done with their children. So because of those findings, ICWA was passed. Donna Lynn is going to share with us the creation story of IFPA. And thank God we have IFPA. Rather than view it as, oh my God, one other harsh thing we have to understand and know, there's more to it than the law. It's about the heart. It's about the spirit that we ourselves, as those who are given power and authority, have to recognize, but more importantly, about the spirits, the souls, and the well-being of Indian children and their families. So some final thoughts. You know, every one of us in this room, because of our positions as judges, have power and authority. Now, without looking into ourselves, although we should regularly, you know, examining our implicit biases, maybe even our explicit biases, we may have dislikes. We may even have hatred for certain things. But by themselves, without power or authority to act, that hatred and dislike can be pretty benign. But as child and family serving professionals, we, each one of us, we are entrusted with great power and authority, and along with that, responsibility. I have to ask myself, and I hope you ask yourself as well, do I exercise my authority and power responsibly? Am I happy and content with the way things exist now? Am I happy with the status quo? Well, a reminder we should all think about regularly. We've talked a little bit about the history, just a very quick thumbnail sketch. But if we ignore history, it will repeat itself. If we don't act appropriately, our failure to do so will be the burden of those who come after us, and very importantly, the children who follow after us, who we ought to be very concerned about in doing the right thing. Thank you all very much. Donna Lynn, come on up and share, please.
As Judge mentioned, I'm going to share, and I'm very honored to share the creation story of IFPA, and was very honored to be part of drafting this over the course of several years. Since 2015, our nation's pueblos and tribes came together recognizing the importance of coming together for our children, and for our children, not just who they are now, but who they are going to be. And so I again want to thank all of you for being here. Justice, thank you so much for creating the space for our tribal partners to be able to show up. New Mexico Children, Youth, and Families is a state organization whose mission is to improve the quality of life for all our children. All of our organizations should honor our indigenous people and communities and their innate relationship with the natural world. New Mexico is home to the Pueblo of Acoma, Pueblo de Colchati, Fort Sill Apache Tribe, Isleta Pueblo, Jemez Pueblo, Hickory Apache Nation, Pueblo of Laguna, Mescalero Apache Tribe, Nambe Pueblo, Navajo Nation, Okeawinge, Picaris, Pueblo of Pewaukee, Sandia Pueblo, San Felipe Pueblo, Pueblo de San Ildefonso, Kiowa Pueblo, Pueblo of Santa Ana, Santa Clara Pueblo, Taos Pueblo, Pueblo of Tesuque, Zia Pueblo, Zuni Pueblo, and Isleta del Sur, who have lived here for many thousands of years, and whose cultures and traditions have enriched and shaped the land we are on, yesterday, today, and tomorrows to come. Native nations negotiated government to government, preserving the sovereign land, rights, and privileges through treaties. When land wasn't ceded through good faith effort, It was often stolen from the first people of this land, our indigenous peoples. Both the state of New Mexico and the United States government carried out genocide, ethnic cleansing, broke promises, and forced removals against the nation's pueblos and tribes as a way to acquire land, and have created policy which forcibly removed indigenous children from their families and tribal communities as a way to eradicate traditional culture, family patterns, and communal ways of living. Despite centuries of colonial theft, violence, forced removals, this is still indigenous land and will always be indigenous land. Indigenous people are not relics of the past, deserve acknowledgement and respect, and are worth celebrating. Acknowledgement of indigenous people is only one small part of supporting indigenous communities in the state of New Mexico. We should all pledge to have meaningful and respectful relations with the sovereign nations, pueblos, and tribes of this land. Chuck Hoskin Jr., Principal Chief of Cherokee Nation, is quoted saying, "The very basic act of sovereignty is a tribe's ability under law to protect their children." As we heard Judge Romero talk about the atrocities that Native nations have faced throughout time, and heard him talk about how Native people were viewed as unfit to raise their own children. It was believed that reservations were so horrendous that children should not be exposed or raised in these environments. And in 1969, the Association of American Indian Affairs discovered 1/3 of indigenous children were removed from their homes, communities, and cultures. 90% of those who were removed were placed in non-native families, often hundreds of miles from their homes. Native children were literally being stolen, and the tribes and their families and their kids had been denied equal protection for forever, and the Indian Child Welfare Act simply established that equal protection. And that's a quote from Bert Hirsch, who is an attorney with AAIA, and one of the authors of the Indian Child Welfare Act. As we move into today, everybody is worried and concerned about the Holland versus Brackeen lawsuit that was brought by 7 individuals in the states of Louisiana, Texas, and Indiana. And as we all know, this lawsuit is backed by multi-billion-dollar special interest group. And the argument is that the Indian Child Welfare Act is racially discriminatory and interferes with the state's authority to protect at-risk children. One of the quotes from our very own Judge Romero states that they're arguing that all placement preferences are based on racial lines and ignoring the fact that tribes are sovereign entities and their members have rights. As we know, SCOTUS is going to make a decision this year, most likely in June, which is just right around the corner. So the creation story of IFPA really centers on the current political landscape at the federal level, and also the years of non-compliance with the Indian Child Welfare Act. So here in New Mexico, how many, just by a show of hands, how many nations, pueblos, and tribes are there? Just raise your hand and yell out your number. 23. Yeah. Judge, I should have made you not answer. Yes, thank you, Judge Collins, for killing that audience participation really quickly. How many pueblos are there? 19. How many Apache nations do we have here? 3 Apache nations. And what is the largest nation here? Navajo Nation. Great. So the nations, pueblos, and tribes have inherent right to exert their sovereign powers in matters of dealing with their members and should should be able to make those decisions regarding their children. Challenges to ICWA at the federal level threaten the well-being of Indian children and families by attempting to undermine tribal sovereignty and self-determination. Native American children are families are also residents of New Mexico. So coordinated efforts between the nation's pueblos and tribes and the state are crucial to provide for the care, protection, and promotion of cultural well-being and the wholesome mental, physical, and spiritual development of children and families. In response to the inconsistent compliance with ICWA and the fact that tribal children are still disproportionately being removed from their homes and communities, like Judge Romero mentioned, ICWA was passed. IFPA was led from our tribal communities, and it is based on the lived experience of our tribal ICWA workers, our tribal social workers, tribal leadership, impacted children and youth, like Veronica and many others, and families who have been through the system. This work was driven by the dedicated efforts of the New Mexico Tribal Indian Child Welfare Consortium, Navajo Nation ICWA, Bold Futures, and the Coalition to Stop Violence Against Native Women. And really quickly, if I could just have all of our tribal ICWA social workers stand up and so we can give them a round of applause. New Mexico Tribal Indian Child Welfare Consortium was formed in 2015, and with the support of many stakeholders, including our very own Melissa Clyde with New Mexico Family, with KC Family Programs Indian Child Welfare Program, have been able to spearhead many things that we've seen here in the state of New Mexico. Once the consortium was formed, really quickly they brought together individuals, stakeholders within the child welfare system who really came together to have these courageous conversations that needed to be had if there were going to be changes in what we see, what the system was continuing to do to our children and to our Native children, families, our communities. And since 2015, have really led efforts around notice, which you will see in IFPA, have really led efforts around and grateful to the work of Judge Ward and Judge Begay in the creation of the ICWA Court in Bernalillo County, and CYFD's own ICWA unit, which is in one of our metro offices in Albuquerque. All of this as an attempt to really not only ensure compliance, not just as a checkbox, but to really, like Judge Romero mentioned, understand the heartbeat and the advocacy that goes into the work that those that you saw earlier standing do. I've been in many meetings with our tribal ICWA social workers, and the way they talk about their children is so much different from the way, we would, I guess through a Western lens that we would expect. Our children are our children. They take the care, consideration, and expect that we would, at being in the positions that we are in, that we would be treating all of our children, our Native children that are in custody, as our own, because they are our own. And like, I'm just so proud of Veronica because she demonstrates such strength and resiliency, and we know that is who we are as a people. So I like to talk about the Indian Family Protection Act, and I often refer to it as a law of testimony. IFPA, as it's otherwise known as, it applies to the following child custody proceedings: investigations, adjudications of abuse and neglect petitions, adjudications of family in need of court-ordered service petitions, termination of parental rights hearings, guardianship hearings, adoptions, and voluntary placement. by a show of hands, how many of you have read IFPA? Yay, that's so exciting because it's only like 157 pages, right? But as you go through and read IFPA, you can hear the stories. You can hear the testimony. And why IFPA is written in that way was really to address issues that our tribes, our tribal social workers, our tribal ICWA workers were experiencing in the present day. So IFPA, the core drafting work of IFPA started happening in, I want to say 2020, and then went through legislative session in 2021 and did not pass, and again continued to work on it, but you can just hear the stories, and so it wasn't that long ago, right? The stories that are in IFPA were what were happening in current proceedings. Nations, the nation's pueblos and tribes are often referred to as the third parent. Governor Riley often said that we are the primary parent. Our nation's pueblos and tribes are the primary parent and should be entrusted to make the best interest decisions for children, which may include the child, the parent, and the resource parent. So oftentimes we would have tribal leaders part of the drafting of IFPA. And you could hear their concern, right? They're looking out not just for that child as the leader, and will often refer to them, to the parents, and to other members of their community as their children. So consistent and meaningful collaboration with the nation's pueblos and tribes. This is paramount. As I was walking around yesterday, we were asked to observe some of the talking circles that were being held. And that was such a key component in each of the talking circles that I was able to eavesdrop in on, is having that communication. How do we change what we're doing? How do we listen differently to the individuals that are in front of us? Notice requirements. Transfer of hearings. Tribes have a right to transfer at any time. Active efforts. There was a group in the back who was having a really engaged conversation around active efforts and placement preferences and what does that look like. I know one of the things that we often hear and my staff often hear when we're called into case consultations is there's no family, right? There's no family, and that's why we can't. That's why we cannot place in an ICWA or now IFPA compliant home. I will just tell you right now, when you hear that in your courtroom, I would really ask you to challenge the department on that, because that's not true. Tribal families, we roll deep. There are families, right? We have a network of aunties and uncles and grandparents and godparents and extended clan family. So really, please hold us accountable to doing those active efforts, to really looking at how we label a placement as suitable placement or not. Cultural compacts are another big piece, and I'm so excited to hear the presentation later on this around cultural compacts. Qualified expert witness testimony, voluntary placement agreements, and compliance. Cabinet Secretary and former Justice V. Hill said, many consider ICWA the gold standard of child welfare. New Mexico's Indian Family Protection Act is the platinum standard. We should want this for all of our children who touch our system, because what Veronica said is so true for our tribal children. It's also true for our non-native children, because they have culture, they have families, right? And so really being able to look and do things and shift the conversation differently so that IFPA does become the platinum standard of New Mexico. It would just be amazing if New Mexico, like, this is just the way we roll in New Mexico, right? We're looking out for all of our children. So IFPA addresses the systematic barriers and challenges with tribes. Collaboration, like I mentioned, with tribes is paramount, and we heard this from our tribes, our tribal partners through the drafting. So throughout every point of the case, CYFD must collaborate with the child's nation, pueblo, and tribe from investigation, and if that investigation results in a legal filing throughout the entire case. The tribe has the right to participate in every stage of the child custody proceeding, no matter whether or not the tribe has intervened. So this was really important to our tribal partners because oftentimes, tribes are not able to retain attorneys to intervene legally. Their voice still matters, and so this was really important. The tribe has the right to all records and documentation regarding the child and the case, regardless of whether or not the tribe has intervened. Notice requirements is really big on that. And even now, right, we hear we didn't get notice, right? And then in courts, what was being heard is, well, the tribe is late. Why didn't you all intervene sooner, right? And the tribe is penalized in court for not intervening sooner and all the time ignoring the fact that the tribe probably got notice 2 months before that TPR hearing that was set in your court. And so really looking for and asking that. And I know that was actually the situation in one of my cases in why ICWA, the Indian, New Mexico Tribal Indian Child Welfare Consortium, thank you, Uncle, was created. I was at ICWA, and my first ICWA case was a New Mexico case, and I had no idea, right? I remember writing a paper on ICWA in grad school, and that was it. And shame on me, right? Shame on me. And so thankfully, we had a great judge and great tribal leadership who said, all right, you need to figure this out. And so we figured it out really quickly. But I got an ICWA notice on children in December, so 2 months after I started in my position at ACMA. Never replied, these are our children, never heard anything again. 8 months later, was getting a call to be the QEW in a TPR hearing.